May I seek indulgence, my lord, in item number 18, 19, they are also for final hearing after remand. So some date may be fixed from Supreme Court.
18-19 कॉल करना जरा एक मिनट.
Item number Sundays.
There are 37 Arbitration Act appeals, my lord, which were decided.
ऑर्डर क्या है सुप्रीम कोर्ट का वो भी देख लें.
उन्होंने कहा कि दोबारा फैक्ट्स और लॉ पर फाइंडिंग रिकॉर्ड होके हमारे पास आएगा तो ठीक रहेगा. बट
The decision is of 22nd August 2019.
yes,
Supreme Court का ऑर्डर नहीं गई.
may I give?
Yes.
इसके आसपास ही रहता है ना.
Within 6 months, 6 months have lapsed long back. We are 1 year.
So first week of the February.
Hmm.
Whenever convenient to us. Today as again it is because the SI matter is continued. So.
We are taking up all the matters now, but we find many cases coming.
Yes, you would see.
After this week, I'll be. All right, keep it on 4th.
Yes.
4th
Please.
Or that to me.
at 2. Prepare a small note.
There are already written submissions on record, my lord, and there is a detailed judgment also available. If your lordship wish to go through, otherwise our written submission of both the sides are there on record with and
You read
the,
the judgment of the Supreme Court.
no.
Yeah, what the Supreme Court says.
That is the problem, my lord. If the Supreme Court would have said that,
Supreme Court says that it is a matter of mixed question of fact and law.
Sir, it is.
And that-
And if it is so, it is 37 would not lie.
no, Supreme Court says, my lord, that they will have advantage
They will
of,
have an advantage only
of
because
finding
the
of this
fact-
honorable court on that
That
when the
means
matter comes up
the
again.
court- the court went into the facts.
No.
It seems so. We will examine it.
But then when it is to be decided afresh, my lord, but that's a reasoned
The
order.
question is whether on this issue, that if it is a mixed question of fact and law, what should be the finding of the court? That is what the court is asking us.
It is, my lord.
Therefore, the reason also the judgment in case of Gayatri Balasamy came earlier. It was that
Gayatri Balasamy is different here.
Yes,
But it did not come at that time.
he
It did
becomes,
not. 25 January.
He becomes
24.
it is April 2000.
he becomes enthusiastic because of the inferences your lordship is drawing, my
No,
lord.
we are not drawing any
Otherwise, the court had not said a single word as to what is the error in the judgment.
34 order also.
Yes.
Yes.
When
And-
they went into facts, we'll see.
Yeah.
Item number 8 says subscribe supplementary 158.
Like रहेगी वो। Yes.
Well, before I start on the merits of the case, one small point about a pending application. So on the 9th of January 25, Mr. Rastogi had been appointed as the amicus for this case by the learned single judge. Then on 10th of February, Mr. Rastogi mentioned that ED has also stepped in and they were also investigating. So since he was the counsel for the UI, he will not be able to assist the court as amicus. So on that day, the learned single judge directed me to implead ED. And next day, the ED was impleaded, notice issued, Mr. Rastogi accepted notices on behalf of the ED. And then ED made certain submissions which are recorded on page 55 to 57 of
So
the.
at the instance of the amicus,
Sir.
ED is appointed.
No.
At that ED is being, notices are
No,
accepted by
no.
the amicus.
No, sir. They are not.
Otherwise, where was the ASG coming in the picture?
See, initially he was appointed on 5/9/125 as amicus.
So
Then on 10th of February, he informed the court 1 month later that ED has stepped in, so I can't now come as amicus.
ED had been impleaded.
Yes, sir. So learned single judge directed me to implead ED.
How ED stepped in?
Sir, ED stepped in of their own, on their own information. Of their own information.
As per the, what we have noticed is that when the court passed an order impleading ED, thereafter the ED stepped in.
No. All right.
Yes.
All right.
This case is concerned, my lord.
Okay.
The
Let me
court
take,
directed to implead.
let me take your lordship to the order sheet, sir. I'll take your
I want to
lordship.
know from you
Huh, sir.
whether the ED had registered any preliminary case against
Yes, sir.
before that date when Mr. R.D. Rastogi says so.
Sir, I'll read page 55 and 57 of the, and Mr. R.D. Rastogi has stated, sir. 9th of Jan and 10th of February, that's the difference. 9th of Jan, he was appointed amicus, and 10th of February. I'll just take your lordship through the order sheets. I'll just take your lordship through the order sheets.
We have had the occasion to look into those order sheets. That's why we are asking you facts.
Sir, I mean, your
That
lordship.
we know that yes, he says so. But we want to know when the ED actually stepped in. Or was it at the instance of the amicus?
Sir,
And
I mean,
therefore-
it doesn't appear from the file that it was on the instance of amicus. It doesn't appear on the. So this ECI was registered on 13th of June 24th. Even before Mr. Rastogi appeared, it had been registered. Within a second file. Very well. Part 2.
Part 2. 20 to 125. 10 to 25.
Sir, may I take your lordship to page 55 of the impugned judgments?
10 to 25.
No, sir. But I'll your lordship's query is directly answered from what is observed there. 10 to 25 is the date when Mr. Rastogi informs the court that ED is investigating, therefore he can't appear there. So then I was directed to implead ED. 10 to 25. Lordship, I see on 10 to 25 at page 4. It is apprised to this court by learned amicus that by order 9125 was appointed amicus to the incident matter. However, as a ED has also intervened into the matter, he represents the Union of India. Therefore, newly impleaded party shall be represented by Mr.
Where is
Rastogi.
that intervening application?
Beg pardon, sir?
Where is that intervening application?
He has just stated it, but later he records. Now kindly see the page 55, para 33 of the judgments. That records the findings. That will clarify the matters. If your lordship could just see these 3 paragraphs. Page 55. Page 55, para 33. Para 33. It recorded on behalf of the Enforcement Directorate. The head counsel appearing on behalf of the Enforcement Directorate informed the court that on 13/2/25, the Enforcement Directorate filed an affidavit before the court apprising that it had initiated an investigation into the paper leak of the Sub-Inspector's Police Examination 21 under provisions of the PMLA. This investigation was initiated by recording an enforcement case information bearing number so and so dated 13/6/24. He was appointed amicus on 9th of January 25. So obviously it predated his appointment as amicus. It has already started.
ECI was registered on 13 June.
6/24. And his appointment as amicus was on January 25. So how can this be said that it is on the instance of the amicus that it was started? Then he says two affidavits were filed, sir. Lordship sees para 34. Subsequently, after initiating the investigation, ED filed an additional affidavit dated 15/5/25 apprising the court regarding the advancements made in investigation. It was informed that in order to conduct a thorough investigation, the ED has obtained details of properties acquired by the accused for the state's financial institutions and revenue authorities. This was done to ascertain the proceeds of crime generated from the commission of the scheduled offences. The court also informed about the material recording of statements of two key individuals, namely Harshvardhan Meena and Rajendra Kumar Yadav, after obtaining due permission from the learned special court. Furthermore, learned counsel informed that subsequent to the filing of the aforesaid affidavit, statements of 6 more persons were recorded under Section 50 of the Act of 2002. This was done in order to identify the proceeds of the crime generated from the commission of scheduled offence. Lastly, the court was informed that ED is taking all necessary steps for conducting a crucial investigation in the matter. The objective is to arrest the kingpins of the organized gangs involved in the malpractices while making inquiries with various banks, revenue authorities, and other authorities to identify the proceeds of crime. Counsel submitted that the object of Act of 2002 is twofold, namely prosecution and punishment of persons involved in the money laundering and attachment and confiscation of proceeds of crime that may be involved in the matter. Thus, it was informed that.
All right.
So therefore, my submission is that ED had already moved into the matter. So now I'm informed that ED has filed a charge sheet. Now I filed an application praying to the court that if that charge sheet could be submitted to this honorable court by the ED.
We are very clear about what we are doing.
Fair enough. So
We
I,
are only examining the case as it was before the signature.
no, of course, it was.
We are not going to make it a big, open this canvas.
Fair enough. All I want to bring to your lordship's notice is that ED was a party.
That will take its logical end.
Fair enough. So
Let the question of our examining ED actually.
lordship may have.
What you want to argue, please argue on your.
I'll do that. But I just want to bring to your lordship's notice that this has happened. And ED had proceeded prior to this.
Happened,
ED had proceeded prior to
with
this.
regard to accused, we are not bothered.
Of course. Lordship is right.
Yeah,
But sir, in that.
Mr. Singh, please remain on the point which is there before us.
Sir,
Whether the examination should have been cancelled
Yes.
or not.
Yes. So,
That's all.
sir, in that
We are
case,
not interested what happens to A accused, what happened to B accused,
agreed, sir.
what charge sheet was issued.
My submission was there are
We
certain.
are not here to even examine. We are not in 482.
Fair enough. What I want to submit through this
We know
is
what is the scope of
that-
a writ petition and how it has to be examined.
that the
And
RPSC
we will
members.
not enlarge the canvas of a writ petition.
Fair enough, sir. Lordship may
Yeah,
then reject my application. I just brought to your lordship notice that there's an application pending. Fair enough.
This is not listed today.
Lordship. ठीक है, sir. All right. So it was listed. It was mentioned to your
Where
lordship.
is this application?
Amar Singh.
It was mentioned, your lordship, that when it's your turn to argue, then you mention this case. So that's why I'm mentioning it.
6 January 2026 it was filed, sir, in Amar Singh's case.
Where is this happening? What is this application?
Sir, it is only the prayer is to. Respond number 131 is the ED sir may be directed to file and place on record before the honorable court the charge sheet submitted before the competent court by ED dated in ED case number dated 13/6/24 or any other ECR relating to malpractice in RPSC recruitment examination. So that is also.
Motion is also filed.
There
You
is
want to press it? Then argue.
sir, what there is a suo motu also pending, sir. So it will only throw more light. That's also. I don't know what to say anything. It's my lordship. I don't want to dwell on it too long.
You want to press this application?
I do not wish to. I do not wish to dwell on it for long. I just want to bring to your lordship's notice about the pendency of an application. That's all.
No, no, but anything has been filed, it has to be disposed of.
Lordship dismiss it.
You do not press it? Or you want us to pass an order?
I'll not waste time on this. Lordship, I'll withdraw it.
Learned counsel does not press the application. Number 1 of the 25, the civil recording because it does not press. Yes, continue.
No, Lord, I'll just very briefly touch upon certain facts that may seem repetitive, but the written examination was conducted from 13th September to 15th of September 21. And between 13th September,
Yes.
between 13th September 21 and 24th September 21, in a space of 11 days, 11 FIRs were lodged.
Yes.
The first FIR was lodged at Palis on 13th itself.
Yes.
And it was lodged by the principal of the center which was conducting this examination. And it transpired that the information relating to what was being done there had originated from Bikaner. And the second
On investigation.
on restrictions. And on 14th, the FIR was lodged at Bikaner. I'll just pass on these.
Yes.
So, Lordship, you see that these 11 FIRs they start from Pali, Bikaner, Jaipur East, Alwar, Jaipur North, Bhilwara, Dungarpur, Udaipur. It covers a wide spectrum of places where these FIRs have been lodged on different days within the space of these 11 days. I'll give 2 copies.
Yes.
But the perusal of these FIRs and the investigations that resulted into charge sheets show that these are not episodes that were standalone. It was a larger design where the entire process was under shadow of doubt. Coaching centers were involved. Paper leak mafia was involved. The schools conducting the examinations were involved. The invigilators were involved. And these informations are passed on WhatsApp.
No, yes, we stop you here. There's a specific submission which you were, whether your colleagues have informed you or not.
They were promised.
That
But you're not sure.
there was no invigilator found to have been involved.
I'll go through when I'm making a statement, I'll take your lordship there.
When you say that they are involved, come to with that, yes,
I'll
whatever.
come to this. I'll come. It is recorded. I'm going to come. So, lordship may see invigilator being involved in 2 ways. One is the invigilator involved in the examination hall because he's doing the invigilation. There he is not involved. The invigilator involved in the leaking prior to the paper reaching the hall. They had been invited. They're involved in leaking the paper and they're in the hall. So in the hall, they have done nothing. They were involved in the processes prior to their commencement.
That case relating to that matrix.
Matrix is one, there are the other also.
See, but that matrix one, where the report is relating to that matrix having take photographs of the paper.
Sir.
The invigilator's name is not there.
It is
Is it there?
I'll come to that. I'll come to that. It's already recorded. So Lordship, you see that it is the end. And just one fact that at any one point of time, if any of the papers was at one incident given on the WhatsApp, that's the end of it. Now you don't know where it reaches. Once it transfers from one WhatsApp to another, then there is no way you can lasso the field within which it would have passed. Then it is up for grabs for everyone and anyone. So I'll show to your lordship in the investigation how it proceeded and how it was passed on the WhatsApp. Incidentally, sir, this is the first time that a state is arguing against its own agency. These are all SOG findings where twice the investigating officer heading the SOG was called to the court to explain the SOG report, and I'll come to that report also. But somehow the state seems to be disagreeing with its own agency. But I'll come to that. Now, Lordship, I come to the next page where I have listed some important dates. These I'm going through because there are certain preliminary arguments that were raised. Objection, they'll be able to, I'll be able to address that. On 4th of May 22, the first writ petition, Kailash Chand Sharma, which had total 34 petitioners, was filed. This I have called it the previous writ petition, seeking cancellation of the examination. After 2.5 months, on 21st of July, that was withdrawn before declaration of the result itself. The result was declared on the 1st of June 23. And then on 3rd of August, another petition, Pramod Kumar and 5 others was filed, seeking cancellation of the examination and direction to the CBI to investigate the malpractices. Now, this is also one of the judgment petitions which have been decided by the impugned judgments. So all documents which were there in when Kailash Chandra filed the second one are part of this also. DG then issued appointment orders, and the state government constituted the SIT on 16th of December 23. And on 1st of February, the first FIR was lodged by the SOG, which related to one dummy candidate. The FIR 1024 lodged on 3/3/24. That is the main one. Now, this showed how the paper leak was initiated. It originated from Ravindra Bal Bharti School in Jaipur. The center superintendent was Rajesh Khandelwal, and Jagdish Vishnu Yang was involved in this. And this paper was transmitted on WhatsApp, monetized, and then solved papers were taught to the candidates near the examination centers by site handlers across the state. And 11 charge sheets have been filed after investigation in this particular FIR till now. And once under 173, it's still open. Now, when this was filed, the next day, 40 persons were arrested, sir. 21 subterranean inspectors and 19 other suspects. And then it was plastered all over the newspapers that these people have been arrested. 40 persons, including 21 subterraneans. Okay. But despite the arrest of 40 persons, despite the SOG having filed an FIR, in pursuance of which 21 subterranean inspectors had been arrested, the government continued to issue appointment letters, and they issued appointment letters on 6th of March, 6th of June, 31st of July. Then Kailash Chand Sharma, who had withdrawn the petition, filed another petition. This time with 25 persons. There were 3 names that were common in these two. The prayers in this was that the final results and appointment orders be declared illegal, action of not cancelling exam be declared illegal, investigation of SOG be monitored by this honorable court, record of SOG be placed before this honorable court, examination held from 39 to 15/9 be quashed, conduct fresh recruitment for appointment for the post of SI, and to treat the petitions eligible whenever the next SI examination is conducted. Now then on 13th, incidentally on the same date, the SOG submitted 100-page reports, approximately 97 pages or so, in 18 chapters highlighting the systematic leakage of the papers and how these gangs had operated, how syndicates had operated, giving entire
Why
details.
did you withdraw your earlier petition?
So that was because I don't know. I can't say why it was withdrawn.
The thing is that there is a specific objection regarding your maintainability.
That is the reason I bring it out. So I'll address that issue when it is addressed. I'll come to that issue whether it is relevant at all and whether it is material. That's why I'm bringing out a lot of notice that the earlier was withdrawn within 2.5 months before the declaration result, though whether the principle of res judicata or even constructive res judicata can be applicable.
Was it that you also were selected in the written part and you had appeared for interview and you did not want to, therefore, if you would have been selected, then you would not have.
Sir,
This is
60
the argument coming forward.
fair enough, sir.
15
Sir, I can answer that, but my submission would be once Pramod Kumar's petition comes in. Pramod Kumar's petition, which I have said it, which was filed on the 3rd of August. Lordship, see the first page, sir. 3rd of August 23, Pramod, fourth entry from top. I just don't wish to dilate on that issue for this reason, that it is actually irrelevant. I can argue it on that as to whether constructive res judicata, etc.
Pramod Kumar was decided along with this.
Yes, yes, yes. That's the point. So therefore, objection in Kailash may not be very relevant. I can dilate, but that will be taking this honorable court's time. Pramod was decided, so if at least Pramod had all the documents of the lead case. So in that perspective, that may not be very relevant that what happened in Kailash, though I quoted Supreme Court judgment saying that unless there is a material concealment, it will not be, I'll not be prevented by res judicata. In any case, it was res judicata, it was not adjudicated at all. So therefore, there are judgments of the Supreme Court saying that I can't be prevented, but just to save the honorable court's time, I'm saying Pramod was there, so Lordship take it that there are all the documents from that perspective.
Pramod's petition was, my lord, even prior to appointment of SIT.
Yes, yes.
And so it could not have contained all those material which my learned friend want to say with regard to the FIR number 10, 2024, which was registered later on, and arrests made, etc. The petition was even prior to appointment of SIT, and he comes after 2021, 10 FIRs are there, comes in 2023 without anything. And I explained to the learned single judge, two petitions were there. One where, my lord, the petition says that the petitioner made a representation. As a matter of fact, the counsel made a representation, and the same counsel files the petition. Those things have not been dealt with. Kailash has been treated to be the lead case, and that is what has been considered. Pramod, etc., my lord, if they let the counsels for the petitioners in Pramod and others argue, I will answer to that. So far, if they say, my lord, that if that is the argument he is making because of Pramod's petition, my petition is saved, my lord, I will answer it later. But he can't say that Pramod's petition contained everything and all that. That is not dealt with in that manner. When the Pramod's case was argued there, the counsel makes a representation and then he files a petition pleading that the petitioner made a representation. This is how those petitions have been filed, my lord. So that will be dealt with separately if they argue. But
Pramod's petition was filed prior to the formation of the SIT, indeed, before that. But subsequently, as the matter was proceeding before the learned single judge, before it was decided, all the documents which were part of the case were also on the record of the Pramod's case. That's all I'm saying. So we can enter into the technicalities, but essence of the matter is something else. Whether there's a systematic failure and whether segregation is possible, probably those are the two crunch issues.
For one day, we have been hearing one technical objection, and you are not ready to answer to that.
committee of, after this on the 18th of 11/24, sir, the Lord Single has directed status quo regarding the with regard to the recruitment process. And then if I may take your lordship through some order sheets, sir. Lordship may just peruse the order sheet dated 6th of January 25. 6th of January 25.
What was the court?
Beg pardon?
Court order.
Yes, sir. Is a
Yes. What do you want us to read?
so in this letter, of 10th of December 24 has been quoted in extenso.
Yes.
So this 6th of January 25, Lordship may come to page 2 of the order sheets. I'm on the third paragraph. To substantiate the contentions made insofar as the lead counsel representing the petitioner has relied upon Annexure 38, that is letter dated 10/12/24, undersigned by the Joint Government Secretary Police, addressed to the Joint Secretary CMO. The relevant extract from the aforesaid letter is reproduced here in below. राजस्थान लोक सेवा आयोग अजमेर द्वारा विज्ञप्ति संख्या फला दिनांक 3/2/21 शुद्धि पत्र संख्या फला 7/6/21 के क्रम में उप निरीक्षक पुलिस प्लाटून कमांडर के कुल इतने पद विज्ञापित किए गए एवं आयोग द्वारा प्रेषित चयन सूची के आधार पर नियुक्ति प्राधिकारी महानिदेशक पुलिस राजस्थान जयपुर ने आवश्यक औपचारिकता पूरी करने के उपरांत नियुक्ति प्रदान करते हुए प्रशिक्षण हेतु आदेशित किया। राज्य सरकार ने विभिन्न भर्ती परीक्षाओं में हुए पेपर लीक की जांच करने के एवं आगामी परीक्षाओं में पेपर लीक रोकने के लिए अतिरिक्त महानिदेशक पुलिस फला की अध्यक्षता में दिनांक 16/12/23 को एसआईटी का गठन किया। एसओजी में दर्ज प्रथम सूचना रिपोर्ट 10/24 अंतर्गत धारा 1600 के अनुसंधान के उपरांत पाया गया कि उस परीक्षा में काफी बड़ी संख्या में अनुचित साधनों का प्रयोग किया गया है, जिसके द्वारा अभ्यर्थियों का चयन हुआ है। इस परीक्षा में अनुचित साधनों के प्रयोग में लाभान्वित सभी प्रशिक्षुओं एवं चयनित योग्य प्रशिक्षुओं का अलग अलग चिन्हित किया जाना असंभव है। महानिदेशक पुलिस राजस्थान जयपुर ने पत्र क्रमांक 22/8/24 के द्वारा अतिरिक्त पुलिस महानिदेशक एटीएस एसओजी के अध्यक्ष की परीक्षा को रद्द करने संबंधी अनुशंसा से सहमत होते हुए एसआईटी की रिपोर्ट जरिए पत्र दिनांक 13/8/6 गृह विभाग को राजस्थान सरकार को प्रेषित की। एसआईटी द्वारा की गई अनुशंसा निम्नानुसार है। द फर्स्ट रिकमेंडेशन इज उप निरीक्षक पुलिस प्लाटून कमांडर परीक्षा निश्चित करने के साथ ही नई भर्ती की विज्ञप्ति जारी की जाए। इस परीक्षा में शामिल अभ्यर्थियों को ही कम से कम 3 महीने का समय देकर पुनः परीक्षा का आयोजन किया जाए। उम्र में छूट देने की भी अनुशंसा है। राजस्थान उच्च न्यायालय जयपुर को प्रेषित किया, जिस पर महाधिवक्ता द्वारा दिनांक 14/9/24 को उक्त भर्ती प्रक्रिया को रद्द किए जाने संबंध में की गई है। महानिदेशक पुलिस राजस्थान द्वारा की गई उक्त महाधिवक्ता राजस्थान से प्राप्त राय माननीय मुख्यमंत्री महोदय के अवलोकनार्थ एवं अनुमोदनार्थ प्रस्तुत किए जाने पर इस संबंध में परीक्षण करने और संबंधित एजेंसियों से चर्चा कर कार्यवाही प्रसारित करने हेतु मंत्रिमंडल सचिवालय अजय से समिति का गठन किया गया। Now these are the 6 ministers that constituted the committees, which included the Home Minister Jawahar Singh Madam. Now उक्त समिति की प्रथम बैठक 7/10/24 को एवं द्वितीय बैठक 10/10 को संपन्न हुई। द्वितीय बैठक में प्रमुख शासन सचिव विधि, शासन सचिव कार्मिक, सचिव राजस्थान लोक सेवा आयोग अजमेर को भी आमंत्रित किया गया। उक्त समिति द्वारा अतिरिक्त महानिदेशक एटीएस एसओजी राजस्थान एवं अध्यक्ष एसआईटी द्वारा प्रेषित रिपोर्ट एवं राज्य सरकार द्वारा इस संबंध में महाधिवक्ता से ली गई राय दोनों का अवलोकन कर व मनन समिति प्लाटून भर्ती परीक्षा 21 के संबंध में निम्नानुसार अनुशंसा की गई है। अध्यक्ष एसआईटी के जांच प्रतिवेदन के आधार पर महानिदेशक पुलिस राजस्थान की अभिशंसा से समिति सहमत है। समिति के समक्ष प्रस्तुत समस्त तथ्यों को विशेषकर महाधिवक्ता की राय के मद्देनजर उक्त भर्ती परीक्षा को जो प्रारंभ से ही दूषित सिद्ध हो रही है और जहां अनुचित साधनों के प्रयोग में उप निरीक्षकों की भर्ती की गई एवं अयोग्य अभ्यर्थियों को चुना, वे भर्ती राजस्थान पुलिस का ध्येय आमजन में विश्वास एवं अपराधियों में भय को सही रूप से चेतावनी नहीं कर पाएंगे। भ्रष्टाचार अपेक्षा राज्य की जनता और राज्य सरकार करती है, जो वर्तमान परिस्थितियों में उक्त भर्ती में चरितार्थ नहीं हो पा रही है। अतिरिक्त महानिदेशक एटीएस एंड एसओजी राजस्थान एवं अध्यक्ष एसआईटी द्वारा नियुक्त प्राधिकारी महानिदेशक पुलिस राजस्थान को उक्त परीक्षा निरस्त किए जाने की जो अनुशंसा की गई तथा जिस पर नियुक्ति प्राधिकारी महानिदेशक पुलिस राजस्थान जयपुर ने सहमति प्रदान की है, को समिति द्वारा भी सही मानकर समस्त तथ्यों पर गहनता से चिंतन एवं मनन करने के पश्चात उप निरीक्षक पुलिस प्लाटून भर्ती परीक्षा 2021 को निरस्त करने की अपेक्षा की गई है। साथ ही समिति अपेक्षा द्वारा यह अपेक्षा की गई है कि राजस्थान लोक सेवा आयोग अजमेर द्वारा पूर्ण पारदर्शिता के साथ पूर्व में आयोजित उप निरीक्षक प्लाटून पुलिस भर्ती परीक्षा 2021 में समस्त आवेदन अभ्यर्थियों को ही सम्मिलित करते हुए पुनः प्रति भर्ती परीक्षा आयोजित करेगा। समिति द्वारा की गई उक्त अनुशंसा के साथ पत्रावली माननीय मुख्यमंत्री महोदय के अवलोकन भेजी गई। So, SOG recommendation agreed to by DGP, legal advocate, the Advocate General, 6 ministers.
This is a letter by the Joint Secretary.
Joint Secretary whom to CMO.
All right.
So at this stage they recommend this and send it to the CMOs for and so then I'll just come. Now on 9th of January when Mr. Sogi had said it was appointed to the Microsoft, on the same day the opinion of the Lordship will see the order sheet date 9th of 25. 9th January 25. It's I think the next order sheet is sent. In this para 2 and 3, Lordship may see. On the astral occasion, it was submitted that despite the opinion formulated by the SIT dated 13/8/24, a report furnished after thorough investigation, subsequent opinion of the Advocate General was sought and the same was granted on 14/9/24. Thereafter, a committee consisting of 6 cabinet ministers was formulated. But in note that the SIT report, Advocate General's opinion and cabinet ministers committee unanimously opined that the recruitment process for the post of sub-inspector for 21 ought to be cancelled, considering distributional conditions and circumstances. In this, Lordship may come to last paragraph, where in para 10 that amicus appointment is there, which I had mentioned before, Lordship, which is now learned. And para 13, opinion of learned Advocate General furnished by the learned AG in the sealed cover envelope is returned herewith. So the court perused the opinion submitted by the learned Advocate General also. Then on 10th of February 25,
That when this letter was already there of Joint Secretary, what was the insistence of the court to hear the matter? It should have been left for the CM to decide it.
so it happened. It came later, sir. Because when we had,
Once this was already there,
sir,
government did the thing, Joint Secretary, examination was to be cancelled. Where was the occasion of the signatures to that?
so the decision had not been taken and the appointments are going on. Sir, our prayer was that they have not cancelled, they should cancel. So either they take a call, because as the time was passing, the training was going on, so it would have been more and more difficult, and they would have later claimed that equity is in their favor, that training is complete. So therefore, after this letter, in fact, once there's a unanimous, there is no dissent anywhere. SOG, DGP, Advocate General, 6 ministers, all of the same opinion, unanimous. I don't think there was any impediment for the Honorable Chief Minister to have taken a call on that immediately. But it was not taken, and that's why we are insisting on this Honorable Court that this decision needs to be taken. But I'll come to that later, sir. Now,
So the court can cancel examination?
beg your pardon?
Court would cancel examination?
Yes, that will be my submission. In such cases, it would. I'll come to that. I'll address that. Now, on the 10th of February, sir, 25, the SIT chief who was heading the SOG investigation was directed to present to the court. And on 11th of February, if Lordship see, as per the direction of this court, Shri VK Singh, ADG SIT has marked attendance and explained the SOG's report and status of investigation. So on this case, on this date, the IO himself, heading the SOG, presented and explained the report to the courts. Now, on 21st of February, that may be your Lordship's query may be partly answered by this. On 21st of February, para 17th, the state sought time. Learned Counsel represented state on instructions of the competent authority has submitted that in the interest of justice and to settle the list in question, government has taken a decision to arrive at a final decision within a reasonable time period. In this background, learned AG has submitted that instant petition can be decided after providing a specific time limit to arrive at a conclusion. However, during the set tenure, state may be permitted to take appropriate actions against the accused who are associated with the controversy, rightly or indirectly. To above situation, all the respective sides have drawn a consensus, but the only qualification that the contentions put forth by the respective sides will remain open on all the grounds. Maintainability merits as open, and the same will not be caused prejudice. And Lordship has see para 18.1, where the state in the background of above matter has prayed time to reach a conclusion. Therefore, the court deems it apposite to grant 2 months period to arrive at the ultimate decision. So we didn't object to it. And if the state takes a call, we are too happy. We will not have to argue the matter and waste the court's time. So 2 months time was granted. Now, ultimately, on the 1st of July, the state reached a decision, and the outlet learned Advocate General has apprised that an additional affidavit has been filed by him. It is contended that as per the minutes of meeting of the committee constituted by the cabinet ministers dated 28/6/25, the recommendation report has been placed for perusal and approval of the competent authority of the government. It is further submitted that the competent authority, that is the Office of the Honorable Chief Minister, has accepted the recommendations of the committee dated 28/6/25 and has duly approved them. So on this date, these were placed before the Honorable Chief, recommendations of 28/6/25 were placed before the Honorable Chief Minister, and that was agreed to, sir. Then the Honorable Court was pleased to call on the order sheet dated 9th of July, the entire record of the case. After some argument, on page 4 of this order sheet, sir, 9th of July order sheet, 9 July 25, page 4, I'm on para 3. As the matter is at a crucial stage of hearing and subsequent events have taken place, for which an additional affidavit has also been filed, it would be in interest of justice to call for the certain record from the state, including the communications commencing from the inception of the SIT SOG till the final decision was arrived at by the competent authority. Additionally, the documents must also reflect the rationale adopted by the subcommittee for the substantial deviation oblique change in its findings, especially when the quorum was of the same strength. Lordship, note this. The judge required that.
Then what was the subject to judicial review which you wanted?
Beg your pardon, sir?
Come to para 4, you did not read this order completely. 1st July.
I'm only reading important things, sir. Yes, which one?
Para 4 of this order of 1st July.
Achha, yes. I'll come to the next one. I'll just comment.
When the Honorable Chief Minister had
Yeah,
taken
yes.
the present batch of petitions are rendered infructuous.
No, this is the argument.
Then learned senior counsel along with others have submitted as well players made on account of foundational errors. Qua the unfair, the decision taken by committee cannot be considered as subsequent development. Subject to judicial review. What judicial review were you wanting for the state? For
No.
the committee?
What happened was, after this, the Advocate General submitted that it has now become infructuous.
Yeah.
It was the Advocate General who submitted that now that we have taken a call, it has become infructuous. Now, our prayer to begin with was not that the state take a call. We said it should be cancelled. That was our prayer. So what I said was there are foundational errors. That was my submission. That in this examination, there are foundational errors, and therefore the state, having taken a decision one way or the other, was not immune from a review by this honorable court. It was still amenable to judicial review.
What is this report of this cabinet minister dated 28 June 25?
Then the subsequent ones. So what happened was, once they were granted 2 months time, take a call. Then on 1st of July, they filed saying that the cabinet, six ministers committee met again, and then they reversed their recommendation.
That we want to know. When was
I'll come to that. I'll quote that. That report was not given to us directly, but has been quoted in this. So
where is that mentioned by the learned senior judge?
it comes later. It will come. Just bear with me. I'll just read one or
So
two.
it is the subsequent report.
Yes.
So the first cabinet recommendations would have been accepted, the petition would have been rendered.
No. And since the same
The prayer is for cancellation.
cancellation, exactly. Sir. Now, Lordship, may note that in this order sheet dated 9th of July,
So
25,
that 28 June 25 committee report,
sir,
was it placed before the court?
said, I think it was
Was
supplied.
it challenged?
It was supplied.
You say that it is subject to judicial review.
So what I'm saying,
Your argument here, which has been noticed, is that you say that subsequent development, that is subject to judicial review.
sir,
So whether that.
sir,
report-
my submission was there are foundational errors. The state had sought a
errors
time.
mean- errors mean if they-
Yes, whatever. And state was granted time to take a call. State took a call reversing the stand it had already taken. So just merely filing another report, taking a reverse view cannot throw me out of the court. It was still within the domain of the honorable court to review that decision taken by them. Because it was taken during the pendency. So Lordship has seen that order sheet.
They challenged it.
No, we didn't. We didn't. And my submission was that I was not required to challenge.
So the signatures could have looked into it.
He could have looked at it. It was very good. In fact, the state prayed, sir, grant us time. He could well have
They
said,
prayed for declaring it infectious.
yeah, state prayed for declaring it. In fact, and we said no, it can't be declared infectious.
So he said that it can be judicially reviewed.
Yes.
So where is that challenge to that?
No, I didn't challenge it. And my submission is, I
Court
did.
would have done it judicially. on
Yes,
its own.
yes, that's my submission.
All right.
So I'll come to the judgment later.
All right.
So now on the 9th of July, the order sheet 9th of July, sir. On page 4, 9th of July order sheet, page 4. I am on para 3, sir. As the matter is at a crucial stage of hearing and subsequent events have taken place, for which an additional affidavit is also filed, it would be in the interest of justice to call for certain record from the state, including the communications commencing from the inception of the SIT SOG till final decision was arrived at by the competent authority. Additionally, now this is important, the documents must also reflect the rationale adopted by the subcommittee for the substantial deviation oblique change in its especially when the quorum was of the same strength. Additionally, the record of the RPSC quad recruitment 21 shall also be made readily available in the court since the issuance of advertisement until now. Caution made clear that no information shall be censored out of the documents. So the learned single judge, when he found that an opinion expressed, agreed unanimously without any dissent, now they take 2 months time and then they take reverse. So whether
It's a subcommittee of the cabinet.
yes,
Can be judicially reviewed.
yes,
Can be examined.
yes,
And that how they reach to that result.
Was accepted by the state finally.
sir.
We would like to know.
Sir, what I'm saying-
Administrative law.
Sir, I'll come to that. Sir. But what I'm saying is, this was finally accepted. It was a state decision after that.
State committee, cabinet committee takes a decision.
Yes,
Then it turns around and it says, no, we will not accept our earlier decision. We change ours.
sir. And state accepts it.
It accepts it. CM sends it back to the committee
Sir.
to
Yes,
re-examine.
yes.
And after the examination, they take a decision. No cancellation.
Accepted that.
Right? That is what the.
Yes.
Now the court would call that record and see how they reach to that reason. This is your order sheet.
No, that's what it is.
Can this be done?
Sir,
We are looking at it in appeal.
I'm aware of that, sir.
Can the court say how the cabinet ministers have reached to a particular reason?
Sir, probably the underlying query.
It's a very thin line where we have to stop, where we
Agreed, sir.
continue.
Yes, but you can see that when it is proceeding on a unanimous without dissent right till through the end, and this has been dealt with the judgment as to
All right, please.
so the entire thing was called, and then Lordship may come to the order sheet dated 10th of July, which is the next one, in which Ninth of July, 10th of July.
Yes.
Now, in this, extracts of the subsequent decision of the committee has been quoted. In Lordship SC B
10th of July.
on the 10th of July. 10th of July. Lordship SC B. The primary basis of challenge for the recruitment of 21 was SIT report, AG opinion, and the erstwhile decision arrived at by the Committee of Ministers. However, it is pertinent to note that since then much water has flown under the bridge as further investigation has been carried out by the investigating authorities, resulting in various arrests pursuant to which a novel decision was arrived at by the Committee of Ministers dated 28/6/25, marked so-and-so. Relevant extent. Now, this was the only extent that was given before us. SIT द्वारा अनुसंधान को आगे बढ़ाया जाए और फर्जी तरीके से चयनित समस्त अभ्यर्थियों को गिरफ्तार कर प्रभावी कार्रवाई की जाए, चिन्हित आक्षेपित अभ्यर्थियों की सेवा समाप्त की जाए एवं उन्हें भविष्य में राजकीय भर्ती परीक्षाओं से डीबार किया जाए, पुलिस उप परीक्षक प्लाटून कमांडर भर्ती परीक्षा 2021 को रद्द करने का निर्णय इस समय लेना प्रीमेच्योर होगा। इस भर्ती प्रक्रिया में शामिल अभ्यर्थियों के हितों की रक्षा करने हेतु आगामी नवीन भर्ती प्रक्रिया में पर्याप्त संख्या में पद विज्ञापित किए जाएं तथा आयु की पात्रता में छूट देने पर भी सकारात्मक विचार किया जाए। Saying this was the conclusion of the committee on the subsequent evidence. This is where they agreed. Now, if I may just read one page of the judgment of the learned single on page 72. Page 72. In fact, Lordship, look at page 71 from where it starts. And look at page 71, para 54.
Yes.
Sir, learned single judges impute judgment at page 71, para 54. What I meant to also notice is that a call was taken initially on the report of the SOG. Then certain things happened thereafter.
Para
54. Page 72. 71. A cumulative reading and analysis of the prayers sought by the petitioners through the present batch of petitions clearly indicates that the challenge mounted by the petitioners directed against the examination process in its entirety, with a specific focus on the purity and sanctity of the said process. The latest recommendations or decisions dated 28/6/25, the subsequent recommendation, does not inherently traverse or nullify the larger challenge posed by the petitioners regarding the sanctity of the examination. Instead, this recommendation of a decision which was made in response to the broader challenge against the compromised sanctity of the sub-inspectors recruitment examination 2021 actually serves to strengthen the contention of the petitioners and making their corresponding prayers more robust. This is particularly so because the further investigation, as detailed in SIT report dated 25/6/25, which forms the basis for the said recommendation dated 28/6/25, highlights the existence of large-scale malpractice in the conduct of written examination. Rather than rendering the petitions or the prayers sought therein infructuous, the recommendations decision dated 28/6/25 has in fact bolstered certain prayers of the petitioners, such as those alleging malpractice in the examination process. This is based on charge sheet number 7F dated 5/4/25, which reveals that the 12 main kingpins wanted in the connection with the malpractice are still absconding. A reward of up to ₹1 lakh has been announced for information leading to their apprehension, and non-bailable arrest warrants have been issued against them. Furthermore, investigation is pending under Section 173(8) of the Code of Criminal Procedure, 82 criminals involved in the case. So my submission is that after the initial recommendations of the SOT, SIT, ADG, etc., were all based on the SOG reports. Then, before the second call was taken by the subcommittee, further investigations had taken place.
Yes, continue, please.
Sir, so
May I Seek your lordship's leave, my lord, for
Yes,
other
yes.
court. My friend is here, my lord.
So what I'm trying to submit for document is that the initial one part was SOG report, DGP, Advocate General, Cabinet Ministers, then sent again. Now before the second call is taken, there are certain more things that have come. Those things the legislature said that these things, if anything, have bolstered our case, not diminished it. Now, on the 14th of July 25, the SOG chief was again called by the courts after the subsequent decision, and then the latest situation was taken. Understood? And on the 15th of July, he was present in the courts. Now, may I just read this order sheet of 15th of July? In compliance with the directions passed by the erstwhile order, Mr. V.K. Singh so has marked his presence before this court and has submitted that whilst no surprise test was administered on 19/3/24 and ad hoc analysis was performed during the investigation to formulate differences regarding majority of candidates, nevertheless, this analysis cannot be deemed tantamount to a surprise test in as much as no marks were lost in candidates with respect thereof. Concerned officer in response to the queries regarding involvement of RPSC members who were also the chief organizer of the examination has submitted that proximate relatives, specifically the nephew of RPSC member Mr. Katara, has participated in the examinations. Furthermore, preliminary investigations have yielded prima facie evidence tending to inculpate him in alleged paper leakage, while candidates Rahul, Katara, and Vijay Damor are also being found complicit in the malpractices. Additionally, submitted that children of RPSC member Ramu Ram Raika were among the top 50 rankers in the examination. However, Mr. Ramu Ram Raika has abstained from participating in the process. Furthermore, submitted that the habitual gangs, including Jagdish Vishnoi gang, were involved in the malpractices. Further investigation has unearthed evidence of widespread paper leakage accompanied by allegations of inter-gang collusion. Additionally, submitted that several other gangs were operations locations such as Bikaner, Udaipur, Pali, and elsewhere, wherein they resorted to unethical practices such as impersonation and utilization of Bluetooth devices. Further submitted that as on date, a total of 53 successful candidates have been apprehended, while 6 key accused individuals and 10 suspects remain absconding. Members see conspirators including Dhaka, absconding, and avoiding detention. At this juncture, Lord Advocate General submitted that the state's bona fides are unimpeachable and was established they preclude judicial review. The further submitted that the investigation revealed that the district inspection was the result of rational and informed decision-making process by cabinet and competent authority. Additionally, submitted that the British have not challenged the said decision. So their objection to thereunto are not challenging the subsequent decision continues. My submission is that it is not required. Because it was an indulgence granted by the court, and the court did not close the matter by saying, okay, let them take a decision, then their file is closed in the court, then they take a decision, then I challenge the question. My submission would be that the second decision was not, it was taken pursuant to a permission granted by the court, and it was always for the court to take a call on whether that is right, considering the facts of the case. So after this, it is seen a little bit of tautology, but SOG, ADG, Advocate General, Cabinet, given 2 months. Then, at the time of this was only all based on their first SOG reports. Only the first SOG report. In which case, the involvement of the RPSC members was not there at all. I'll come to the SOG report. RPSC members' involvement was just suspected. There is one line in that report that Katara के बच्चे हैं, रायका के बच्चे हैं, तो संदेह पैदा करते हैं. That's all. One line. Then after this, when they have already taken a call on that report, that it should be cancelled. Then RPSC comes in, RPSC involvement is there. They furthermore has said, which bolster my case, the concept which is actually incomprehensible. Because subsequent things have, if anything, bolstered my case. RPSC's involvement has come. Board understanding made. There is nothing to dilute my case. And therefore, the SOG chief was called twice to the court to understand that. And the court also asked them as to what is the rationale for you to reverse a unanimous decision taken without any dissent at all. That's where it was. Now, come to the next case where I'm dealing, where they have said that I concealed.
You got the.
I passed the notes. If you're Russian, like me.
Direction very fast.
I understand. In the note on next points, I've said dealt with the concealment and suppression. They said that we had not disclosed in the second petition the fulcrum of their argument with regard to second petition was that we had not disclosed. That we had not disclosed that we had already filed a petition and withdrawn it. That was the gravamen of their argument given the Land Civil Judge. Now, these three judgments that I have quoted, which has been dealt with by the Land Civil Judge from page 58 to 63 in the review judgment, say that the concealment has to be material. That concealment has to be in a manner that affects the decision of the court. If I am trying to overreach the court, and that concealment has actually helped me in getting an interim order, then it is a material concealment. Otherwise, if it is not stated and it is not affected the decision of the court, it is not a material concealment. Now, I think that's where it has been done. Page 58 of the influence.
Of the judgment, of the single bench.
Yes, yes. That's right.
ये LCS है, उसमें कितना होता है? LCS में था, LCS में था। अब BS के directors में दोनों को देखो।
That's all page 50 is a para 37. So in this is a note I will just point out on where the judgment starts and index has been given.
Previous conduct.
Yes, and index is there on page 17 of the judgment, where the judgment starts. There's an index.
Which is at page 40 that we have discussed this after.
No, sir.
Para 40.
Sir, para 77 starts with the but
That is part which he has quoted to the objections.
sir, yes, sir.
Come to para 40.
Yes. In the course of arguments on the noted objection, the Lord Advocate General has apprised the court that the petitioner has brought the court the entry and has continued evidence by the fact that the petitioner has conceived material circumstances that year 22. A petition substantially similar in nature that they have largely applicable to those in the petition to file before the Honorable Court, but as well as the petition. However, the said petition of this was withdrawn without any liberty being granted to the petitioners to file a fresh petition. The concealment of this vital information, the argument involves the principle of constructive res judicata, which necessitates that the petitioners be barred from pursuing the entire challenge so raised in the present petitions owing to the dismissal of the previous petition as dismissed as withdrawn. Thus, it was contended that by the Advocate General that the said concealment was deliberate and out of fear and apprehension that the present petitions would be dismissed on the basis of such prior proceedings. Hence, owing to such concealment and unclean approach, the present petition were to be dismissed. Upon having meticulously scrutinized the record presented before the court, specifically the particulars of the petition previously filed in 22, Director Kalakshan Sharma and others versus State of Rajasthan, the broader contextual framework within which the challenge to SI recruitment examination 2021 is being raised by the petitioner hearing, this court is unable to then credence to and or accept the argument without the right possible response. Notable principal legal jurisprudence that a fact conceived by the petitioner can only have the effect of persuading the court that the petitioner has thrown the court with unclean hands when such concealment is not merely an inadvertent omission, but is instead a material concealment within the contextual framework of the litigation. For a fact to be deemed material, it must possess such a degree of relevancy to the issue at hand. Had the court been apprised of this fact, a majority of the contentions raised by the parties to the dispute could have been expeditiously resolved at once or significantly impacted thereby. In other words, the materiality of the concealed fact is to be gauged by the potential to substantially influence the court's consideration of the matter, such that knowledge of the fact would lead to a swift or conclusive determination of a significant portion of the issue in dispute contention. Therefore, in the facts as concerned the present batch of petitions, the key question posited is whether the fact of the petitioner's failure to inform or apprise the court about the previous filing, as we saw so, had it been known to the court earlier, would have likely influenced the court's decision or affected the outcome of the proceedings. The answer in the particular circumstances is in the negative for the following reasons statements. Previous petition was filed by 34 individuals, out of which only 3 are common in the area of petitions in the present batch of petitions. On a juxtaposition of the relief sought in SP so-and-so and present petitions, it becomes glaringly evident that the overlap is not absolute, as earlier petitions were done almost 1 year before the results of the recruitment process were declared, and the said petition was withdrawn on 21/7/82, wherein the impugned final result, which is paid to be quashed in the present petition, was not declared until 1/6/23. Actually, there are glaring developments and significant changes in the treatment of the present batch of petitions. SOG was constituted amongst almost 17 months after the withdrawal of the petition. There is on 16/23, followed by logical FIR number 1024 on 3/24, and the consequential first arrest on 4/24. Glaringly obvious that the petitioners approach this court on a fresh cause of action as executed to the present batch of petitions, which is discernible from the fact that despite the malpractices being widely known and admitted, appointment orders were issued by the respondents on 6/6/24 and 31/7/24. Therefore, the filing of the present batch of petitions on 31/8/24, pursuant to such appointment orders being issued on the basis of their final result so declared, is not concealment but rather a mere omission which could not attempt the bar of the judicata, owing to the discrepancies and developments in the facts as well as rare sought in the two sets of petition. The more nuanced rationale to settlement of the claimed bar of constructive res judicata, which as displayed above has no factual applicability, is the fact that in the present factual context, the larger public interest is at stake, and calls to such public interests must be timely and efficiently answered.
If this is allowed, that one batch of petitioners come before the court, start arguing their case in length, orders are passed, later on respondents also come. And it becomes sometimes obvious where the judgment is going or where the judges are. And the judge says, the lawyer says, all right, I withdraw my petition. And the court allows him to withdraw the petition. And after, say, for example, after 6 months or 8 months, another writ petition is filed, challenge making the same prayers. Can it be allowed? Would you say that because they have not materially concealed anything and there are certain developments which have taken place, so we should entertain the petition? Because when we asked you specifically, you do not know why he withdrew it. It could be because the court was not going in his favor. And instead of getting a judgment on merits, he withdrew the petition. And then later on he comes back again.
I get lots of queries. If I can respond.
And he also takes parts, he participates in the selection process.
Now, let me take a lot back to the list
It
of
would be too wide if we take such a view.
Sir, my suggestion it is not. It has to be.
When we lay down a law, it has to be applied in all facts.
Yes. Now, my suggestion is that the view has to be a little more nuanced. In the sense that
Just that because we are influenced with the issue involved. The issue which may be of general importance. Issue may be very important, very much required to be adjudicated. But the court does not become a litigant.
Yes, sir. I'm not right, sir.
We may feel many things about many things, but if the petition has been filed and it is withdrawn,
Sir, now let me respond to that, sir. If I promise. Lordship had rightly said that the crux of what your Lordship said was that generally we come to know the court view and then withdraw and then come. A kind of overreach a little later.
you're finding it.
Yes. So
People go to that extent. Thing we will inform you. People are filing petitions here. Petitions are being dismissed here. And then they go to Jodhpur and file a petition there with another 2 names on the top. Their name is there. And another petition is filed.
I can see.
Bail application, order passed here. Bail application dismissed. 482 petition filed there. And a stay granted.
See, I can see it.
We have to. We can't allow this kind of
Absolutely. Lordship is absolutely right. So I'm not.
just because the issue is for us, no issue is big, no issue is small.
Absolutely. I can see it. So therefore, I'm not disputing it. What I'm saying.
When he says that because of these reasons, the larger public interest is at stake.
Is one aspect. Sir, it is one aspect. No. Sir,
A litigant who has already approached the court, he takes a chance. He then also takes a chance whether he might get selected.
I guess so. No,
Say, maybe those others are unscrupulous people.
I
But
can see.
whether you're,
Sir, my submission would be that a more nuanced view has to be taken in this case for the reason that if you're not able to see the facts of the case, whether it will appear to your lordship conscious that yes, that can be suspected. Now kindly see, I have taken lordship back to the importance. Just can I have a look at it? Yes, sir. Here will be thrown.
we don't say that the examination should not have been cancelled or not.
I'm not going there. I'm still on the point which your lordship has.
Yeah.
I'm on that point. I'm only exclusively on that point.
Yes.
Now, whether these facts can even slightly persuade your lordship to take the view which your lordship has quoted that they are put to etc. Kindly step in. 4th of May 22. 4th of May 22. 2.5 months later, that petition is withdrawn without liberty. 2.5 months.
But the process was started in that petition. Notices were issued.
Yes.
Yes, notice that petition.
Or the respondents had already put in their appearance.
Yes, that
Everything was there.
Yes.
Arguments were there.
Reply was filed.
Then-
Reply filed.
Yes.
It was not just one thing. It was not adjudicated. Because when they come to res judicata or constructive res judicata, I'll come to that. Okay, what does res judicata mean?
With regard to withdrawal, it has already been there. There's a full bench judgment, I believe, of the
I'll come to that. Yes, I'll come to that. So now, within 2.5 months, that is withdrawn. Now,
whether withdrawal would amount to res judicata or not, that has already been settled.
fair enough. Fair enough. Now,
It does. It does bar a second writ petition
so, sir, let me.
on the same merits.
Let me.
Is there a full bench judgment of this court
Sir, let me.
Yes,
on withdrawal?
yes.
Once it is withdrawn, it cannot be filed again.
Sir,
If the liberty is not being
And full bench has said it is absolute bar.
absolute bar.
Sir, may I for a moment assume that Kalashan's petition was not maintainable? What about
We are examining this aspect of the signature. Right. We will look into the other aspect,
Yes.
which you have already said.
So my submission is that when the second was
And
filed,
you are supporting this aspect of the signature observation.
no, sir,
Yeah.
there are 7-8 points you taken. So
Yeah.
my first submission is
That's the thing, we are hearing you on merits,
How many six?
whether you are supporting this aspect. That is what we are asking you.
Sir, this he has.
We have read this,
Sir,
but whether you support this or not,
sir,
even if before the signature, even if the facts are quite glaring, the court may personally want to entertain these aspects, would want to examine it.
sir, in the
The argument which has come from him is that the course would have been that he would have taken these aspects as a suo motu and sent it. Once the court reaches to the conclusion that these are important questions
Sir.
which need to be examined on the ground of larger public interest, as he says. The argument which was taken is that they should have then the course adopted should have been to send it to make it a suo motu petition, not allowing the maintainability of the petition, which is the correct approach and should have been brought. This is what the Advocate General has argued.
Sir, now what I was saying is that 34 petitioners filed a petition which was withdrawn with one hour after the decided. Thereafter, RPSC certificate, thereafter SIP certificate, thereafter SOG files an FIR in which there are 14 arrests made, and thereafter they continue to issue orders. It is dead. Then the second is filed, which is again was in 22. The second was filed in August 24, more than 2 years later.
He conceals this. You are on concealment here.
So, here 34 people were there, next 25 are there, there are 3. Not, it is not a new which is filed by you. There are 34 here, there are 25 here, 3 people are found. That is one thing. Secondly, Lordship received a gap of more than 2.5 years. And at that time, when has been made and still not being action exercised.
Question is, even if there was not even a single person common, if second petition would have been filed with regard to the said, the fact regarding earlier petition having been filed relating to this has to be brought to the knowledge.
Now,
That also would have to be brought. So if a person who was already a party in the earlier petition and does not inform the court whether it is not material or not, that's what the judge says, that it is not immaterial.
So, yes, Supreme Court says so. Supreme Court says so, I didn't hear you. It says that unless the concealment resulted in some gain, unless the concealment resulted in some gain, it is not material. So these- Here, sir.
What is the meaning of gain here? So it earlier was dismissed, and this is a gain or not? And once you,
Suppose these are common. There will be common. 25, 24, and 3 people common. Suppose these are not there.
suppose we don't want, then we would have asked them another thing. Why did you not inform about the earlier case? That's another aspect. Because the earlier case, the court might have examined it. And as we asked you, once the court reaches to a conclusion or is about to reach to a conclusion, and the lawyer says that we want to withdraw the petition, and we allow him to withdraw the petition. And then later on, concealing everything, we had filed a petition, and we had withdrawn it. That might have been after 5 years. The issue, if the same been already been dealt with, examined, but withdrawn, which amounts to decision, a decision which has already been rendered by the court. We do it time and again. PILs are also being withdrawn. If that is allowed, then second PIL will come, third will come. You have seen this happening. Even in PILs, people come to us.
Yes.
And after, when they see them, what is the, we may say in a single, what is the mood of the court?
That's always possible. Yes, always. Yes. But my
In fact, while sitting in Punjab, I would not allow a single case to be withdrawn. Once the case was heard on merits, and if I had started dictating, I would never allow a person to withdraw.
That's a very robust judicial process for that.
That's it.
Don't,
This is the reason why. This is the main reason.
I can see.
Once the court has applied, has expressed its mind, it should come in black and white because it's a court of record.
Absolutely. Absolutely.
So this is what why we say it's because court of record is a different thing altogether.
There are withdrawals and mentions.
Yeah, that is what, but it creates.
Your lordship is right. Sir. This avoidable. We are dilating on this point. These kinds of things are avoided when you don't permit withdrawal. They are dismissed. So at least we don't have to sort of devote time on these things. But anyway, may I take your lordship to a Supreme Court judgment? 3 Supreme Court judgments on the subject.
Yeah.
Volume 2, sir. Volume 2 we have passed.
Yes.
Volume 2. Speak.
शुरू कौन सा होता है?
Volume 2.
Yes. The judgment starts at page 295. The first page 295, 3 judges bench, sir.
Yes.
Lordship may. Now, in this, your lordship may come to page 326, sir. Suppression of material facts by the appellant. Para 33. Merits.
Yes, please.
Sir, Counsel on behalf of landowners have contended that the contempt of the appellants disqualifies them from seeking any relief. They assert that the appellants filed the present petition specifically under Group B1 without disclosing that civil appeals filed by another appellant authority against the same impute order has already been dismissed. Furthermore, the section is deemed as providing an inaccurate declaration under Article so and so, Order so and so. Before addressing the aforesaid contentions, we may refer to the law laid down in this regard. A bench of 2 honorable judges of this court in SGS Business Enterprises held that the fact suppressed must be material. That is, if it had not been suppressed, it would have influenced the merits of the case. It was held thus. As a general rule, suppression of a material fact by a litigant disqualifies such a litigant from obtaining any relief. This rule has been evolved out of the need for the courts to deter a litigant from abusing the process of the court by deceiving it. But the suppressed fact must be material, one, in the sense that had it not been suppressed, it would have had an effect on the merits of the case. It must be a matter which was material for the consideration of the court, whatever the view the court may have taken. Assuming that the explanation given by the appellant that the suit had been filed by one of the directors of the company without the knowledge of the director, who almost simultaneously approached the High Court under Article 226 is unbelievable, the question still remains whether the filings of the suit can be said to be fact material to the disposal of the writ petition on merits. We think not. The fact that a suit had already been filed by the appellants was not such a fact that suppression of which could have affected the final disposal of the writ petition on merits. Further, bench of 2 honorable judges of this court in Arunama Barua, following the aforesaid term, held thus. It is right law that so as to enable the court to refuse to exercise its discretionary jurisdiction, suppression must be of material fact. What would be a material fact suppression whereof would disentitle the appellant to obtain a discretionary relief would depend upon the facts and circumstances of each case. Material fact would mean material for the purpose of determination of the list. The logical corollary whereof would be that whether the same was material for grant or denial of the relief. If the fact suppressed is not material for determination of the list between the parties, the court may not refuse to exercise its discretionary jurisdiction. It is also trite that a person invoking the discretionary jurisdiction of the court cannot be allowed to approach it with a pair of dirty hands. But even if the said dirt is removed and the hands become clean, whether the relief would still be denied in question. Law is well settled. The fact suppressed must be material in the sense that it would have an effect on the merits of the case. The concept of a suppression or non-disclosure of fact transcends mere concealment. It necessitates the deliberate withholding of material facts, those of such critical import that their absence would render any decision unjust. Material facts in this context refer to those facts that possess the potential to significantly influence the decision-making process or alter its trajectory. This principle is not intended to arm one party with a weapon of technicality over its adversary, but rather serves as a crucial safeguard against the abuse of the judicial process. Nevertheless, we have carefully considered the orders issued by in the first round of litigation, which are alleged to have been suppressed. Despite reviewing the order, we find no compelling reason to dismiss the appeal based solely on the prior dismissal of appeals by some other appellant authority. Well, this is Lordship may see the SGS business on page 350. Sir.
It starts from 350.
Just a sec.
Starts 350, sir.
Page starts on page 350, and I am at para 8 on page 356. Sir. Para 8 on page 356. May I read para 8? It's at page 356.
Yes.
When the writ petition came up for disposal, the learned single judge dismissed it, holding that as the appellant had suppressed the fact that it had filed a suit prior to the initiation of the proceedings, its conduct verged on the fraud, and that the appellant had disentitled itself to any relief in extraordinary prerogative writ jurisdiction. It was also held that the Bikiko had acted bona fide in taking action under section 29 and selling the hotel. While dismissing the writ petition, the learned single judge directed Bikiko to consider the appellant's application for one-time settlement in accordance with the law. Bikiko was directed to hand over the possession of the hotel to the respondent 6, and appellant was directed to pay 10,000 by way of cost to respondent 6. Division bench dismissed the appeal preferred by the appellant after rejecting the explanation given by the appellant that the two proceedings had been initiated independently by two directors of the appellant, each without others' knowledge. The division bench held that the court would not interfere with the single judge's order because of the material suppression of facts by the appellant. Lordship may then come to para 12, sir. The principal basis on which the learned single judge and the only ground on which the division bench and the High Court refused leave to the appellant was because they found that the appellant was guilty of suppression of a material fact with filing of the suit prior to approaching the court under Article 226. As a general rule, suppression of material fact by litigant could disqualify such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter litigant from abusing process of the court by deceiving. But the suppressed fact must be material in the sense that had it not been suppressed, it would have had an effect on the merits of the case. It must be a matter which was material for the consideration of the court, whether whatever view the court may have taken. Thus, when the liability to income tax was questioned by the applicant on the ground of her non-residence, the fact that she had purchased and was maintaining a house in the country was held to be a material fact, the suppression of which disentitled her to relief claimed. Again, when the earlier proceedings before this court, the appellant had undertaken that it would not carry on the manufacture of liquor at its distillery, and the proceedings before this court were concluded on that basis, a subsequent petition for renewal of the license to manufacture liquor at the same distillery before the High Court was held to have been initiated for oblique and ulterior purposes. An interim order passed by the High Court in such subsequent application was set aside by this court. Similarly, a challenge to an order of fixing the price was rejected because the petitioner had suppressed the fact that an agreement had been entered into between the petitioners and government relating to the fixation of price, and that the impugned order had been replaced by another order. Assuming that the explanation given by the appellant that the suit had been filed by one of the directors of the company without the knowledge of the directors, who almost simultaneously approached the court under Article 26 is unbelievable, the question still remains whether the filing of the suit can be said to be fact material to the disposal of the petition or merits. We think not. The existence of an adequate or suitable alternative remedy available to a litigant is merely a factor which a court entertaining an application Article 226 will consider for exercising discretion to the issue a writ under 226. But the existence of such remedy does not impinge upon the jurisdiction of the High Court to deal with the matter itself, if it is in a position to do so on the basis of the affidavit filed. If, however, the party has already availed of the alternative remedy while invoking the jurisdiction under 226, it would not be appropriate for the court to entertain the petition. The rule is based on public policy, but the motivating factor is the existence of a parallel jurisdiction in another court. But this court has also held in Chandrabhan Gosai that even when an alternative remedy has been availed of by a party but not pursued, that the party could prosecute proceedings under Article 226 for the same relief. This court has also held that when a party has already removed High Court under 226 and failed to obtain relief and then moved application under 32 before this court for the same relief, normally the court will not entertain the application under 32. But where in the parallel jurisdiction the order is not a speaking one, or the matter which has been disposed of on some other ground, this court has in a suitable case entertained the application under 32. Instead of dismissing the petition on the ground that the alternative remedy had been availed of, and the court may call upon the party to elect whether it will proceed with the alternative remedy or with the application under 226. Therefore, the fact that a suit has already been filed by the appellant was not such a fact that suppression of which would have affected the final disposal of the petition. So the point being, the concealment has to, the third case is of Arunima Barwa, sir.
Is 360.
360.
Yes.
In this para 2, sir. How and to, just 4 lines. How and this is on page 364.
Same, it was relating to civil suit.
No, sir.
Filed for the same.
Yes. So the point being that
Bar of filing writ petition on ground that civil suit was filed is not so seen. Not seen as a.
Sir, the logic, the gravamen of a judgment is
the powers which we exercise under Article 226.
I can see, sir.
Different, and the scope is totally different from that in the civil.
Sir, in BSK Realtors, it was a.
The petition is filed under 226.
Sir, no, in BSK it was a writ, sir. In BSK Realtors, it was a writ. In BSK Realtors. So, no, sir, I'm sorry.
None of them.
Civil appeals. So,
In the first one, what had happened is that one party had gone in appeal. The other party files an appeal later on. The first appeal is dismissed. The ground argument is that in first appeal the issues have been decided. Court says no.
I guess, sir. Now, what my submission is that the logic underlying the rejection
Logic is with regard to successive writ petitions.
So the logic by the law laid down under this with regard to suppression of facts and dismissal on this ground of suppression. In this is what is material.
Suppression of fact is not with regard to facts of the petition. That is the difference here. We are not talking about suppression of facts relating to the
No,
facts of the case,
relating to earlier.
relating to the attempt to litigate
Sir.
earlier and not being successful and again coming back.
That's right. So my submission would be that if I had just put, we put notes in the end, that I had filed A, B, C, D, we put 4 notes, had there been also E, the 3 of the petitioners had filed a petition earlier, that would not have affected the trajectory of what was these proceedings. That's my submission. The trajectory of these
It
proceedings
is
would
not
not
in the foot. It is not in the footnote.
No, it's not, that's what I mean.
It is not part of the footnote. You have to mention it in the part of your petition.
Suppose, even in the ground or in the body of the petition.
That is the affidavit.
So had it, what I'm saying is, had it been mentioned in the petition or
Come to para 39, page 48 of your petition. The petitioners have not filed any such petition in the same matter either before this one.
what I'm saying is, that is, I concede.
The entire sanctity of an affidavit goes away, sir.
I concede, sir.
If this is allowed, and if we lay down a law,
I
that
concede.
if this is not, then we will have a.
I concede, sir. I concede. What I'm saying is, here in the larger context.
Once you concede, we go on the second point. Let's go on the other points.
But my submission would be that this sanctity of affidavit is one aspect. But what
Not one aspect, it is.
It's a very important.
Everything has to be read together.
Sir, by saying that a wrong affidavit was filed, I'm not trying to dilute the gravity of the offence. What I'm saying is that the putting of this fact on record of the petition, that the earlier petition had been filed and withdrawn, would not have affected the trajectory of this case. That's what I mean. Though this wrong affidavit is definitely a grave error, and I mean, a lot to stand on that. There's a grave error. There's no denying that. But the trajectory would have not been affected of this entire case, considering that Pramod was filing and Pramod had the same facts. So this would have been Pramod would have been decided.
We will examine that aspect. So that's why we want you to say address only other aspect.
Right. I come to the next one. Sir, the second point that was raised was about the res judicata. Now that has been dealt with from page 63 to 68. So it is in para 45. Page para 45, page 63. At this juncture, this court deems it appropriate to reference the dictum of the Honorable Apex Court as enunciated in National Federation Confederation of Officers, where the Honorable Apex Court held that the principle res judicata would not apply where there was no decision on the merits of the case in a previous petition. In a sense, the Honorable Court clarified that the previous dismissal of a similar petition did not involve a substantive adjudication on the merits. Therefore, the principle of res judicata would not bar the subsequent litigation. Similarly, upon a corresponding application of the said holding in the present factual matrix of the case at hand, it becomes glaringly obvious that petition number so and so was withdrawn without having any discussion, stroke adjudication on the merits of the pair sought, which have also been significantly altered since the declaration of the impugned final result dated 1/6/23. The relevant extent of the dictum enunciated is produced below. The petition was summarily dismissed by the court on 10 December 2 in the following terms. We are not inclined to entertain the petition, which is accordingly dismissed. The principle of the res judicata and constructive res judicata, which section 11 of the CPC embodies, have been applied to the exercise of writ jurisdiction, including public interest litigation. Yet courts have been circumspect in denying relief in matters of grave public importance on a strict application of the procedural rules. In so and so, the court observed, writ petitions before us are not inter partes disputes and have been raised by the way of public interest litigation, and the controversy before the court is as to whether, for social safety and for creating the hazardless environment for the people to live in, mining in the area should be permitted or stopped. We may not be taken to have said that the public interest litigations procedure laws do not apply. At the same time, it has to be remembered that every technicality in the procedural law is not available as a defense when a matter of grave public importance is for consideration before the court. Even if it is said that there was a final disorder in the dispute of this type, it would be difficult to entertain the plea of res judicata. As we have already pointed out, when the order of 12/385 was made, no reference to the Forest Conservation Act of 80 had been made. We are of the view that leaving the question open for examination in the future would lead to unnecessary multiplicity of proceedings and would be against the interest of society. It is meet and proper as also in the interest of the parties that the entire question is taken into account at this stage. While determining the applicability of the principle of res judicata under section 11, the court must be conscious that grave issues of protest are not lost in the woods merely because the petition was initially filed and dismissed without substantial adjudication on merits. There is a trend of poorly pleaded public interest litigations being filed instantly following a disclosure in the media with a conscious intention to obtain a dismissal from the court and preclude genuine litigants from approaching the court in the public interest. This court must be alive to the contemporary reality of ambush public interest litigations and interpret the principle of res judicata or constitution in a manner which does not debar access to justice. The jurisdiction under 32 is a fundamental right in and of itself. In this case, is a three-judge bench court rejected the petition filed by Met Mines Mazdoor Sangh in limine without a substantive adjudication of merits of the claim. The present petition is not barred by res judicata. Similarly, in Dayao, a constitutional bench of the Honorable Apex Court held that orders dismissing the petitions in limine will not constitute res judicata. The court noted that while a summary dismissal may be considered as a
Article 32, sir.
Sir, what I'm saying is, again, I'm on the logic of the
Article 32 is what? Fundamental right. Taking away a fundamental right. There you exercise
sir,
power under Article 32. The second
Sir,
Darya was also 32.
It was in 32, yes.
And we have a full bench judgment of our own High Court.
Sir, res
Withdrawal is ground on which second petition would not lie.
Sir, res judicata is.
What about the full bench judgment of this court?
So this is not. They should have. They could have quoted. They didn't quote it. So. So I don't know. Not quoted here. But anyway, my submission.
Ours have been quoted, that is the grievance. That is the grievance.
अगर affidavit पेश किया हो सर,
Written-
then the law is very clear. कि अगर नहीं कोर्ट किया तो affidavit पेश करके आपने ये कहा था ये लेटर सिंगल जजमेंट में नहीं लिया. That's very clear law.
Shown the
No, no.
pleadings.
I am not required to do that because on the day the submissions were made, the court itself records that these judgments have been relied upon. And then when the judgment is written, none of them have been quoted. That is the grievance, my lord.
It's a part of the order sheet,
Sir, my submission was.
where he quotes the judgments which the learned Advocate General has cited.
So
They are not dealt with in the final.
There are.
So please don't go on these aspects. Please come on the merits of what you want to say.
I was actually wanting to skip the initial objection and come to merits, but your lordship, you have to address, so that's why I'm coming to this.
You have to attach all the aspects, but not where you know that yes, you can be fair enough to the court.
So what I'm submitting is that the underlying principle of this, that is the reason I said Pramod is there. Kailash be dismissed.
That you started with, and we have noted it.
So therefore,
We have noted it.
in fact, having stated Pramod,
But you say principle of res judicata,
sir, what my,
cases of withdrawal. will
sir,
apply.
my submission from the beginning was leave alone Kailash, only consider Pramod because all facts are there. So I would have straight come to the merits of the matter.
Go ahead with it. Whatever you have to say, please, on merits. you say.
So what my submission would be that since Pramod was there and all facts, all documents which were on the lead case were there, so lordship had taken that Kailash would dismiss wrong affidavit, res judicata, everything. Pramod is there, so therefore let it get done. That's all right. That would be my submission.
All right.
So lordship, I just note one particular aspect only on this note that I've said, that when the SOG report was filed on the 30th of August 24, a total of 64 arrests had been made, including 37 trainee SIs. And this entire spectrum till the committee of ministers was based on this SOG report. The first where they said cancel, and the whole thing is vitiated. After that, 32 SIs were arrested till the judgment of the legislators. And it is in this period that the involvement of RPSC was also revealed. So RPSC is addition, 32 more arrests are made, and a reversal takes place meanwhile of the decision of the committee's recommendations. And then even after the legislature judge's judgment, 9 more arrests have been made of the SIs. My point is that I'll come to later, that this is a continuing process. When they say we reach a conclusion, that the investigating agency has said at more than one place. Firstly, that it is unending. There are 12 kingpins not traceable. There's Haryana gang, there's the UP gang, the Haryana gang chap has died, and therefore they will never reach a conclusion is one aspect. But also that the segregation is impossible in the way because it has been thrown around on the WhatsApp.
This is what we want to know. When the second SOG report has been submitted, it says that we can identify those who are accused, who have participated, who are involved, and those who are innocent can be left out. Now, if that can be done, this is what the Advocate General says. If that can be done, and therefore it is premature to cancel the examination. The decision was taken only for this reason, that the SOG has come up that yes, they will be able to identify all those persons who were involved in not that he supports the cheating which has been done, not that what has been done, but that whether the people who are innocent, they should be made to suffer. More so when they have all come from very different government, they have left their jobs, some may have become overage. They also participated, that is also part, that they also were selected in other competitive examinations and left those and joined this post, including RAS.
Yes, sir.
40 of them.
421.
Huh?
421 passed the exam, RS exam.
RAS examination. So that is the situation.
There are what has the SOG report said in those 18 chapters and 97 detailed reports?
No, that was the initial one. The subsequent one, which we don't have with us also, and it was but it was before the concerned ministers. It was before the CS, and they took a decision that it would be premature at this stage to cancel the examination. At the same time, they also took a decision that if new advertisement is being done, then there should be an age relaxation granted.
That.
The single judge says that these two are contrary.
It was also
The
before
single
the
judge
civil
says that if this was premature for cancellation of examination, there was no occasion for also observing that there should be age relaxation. We have not been. You please make us understand how we have reached to this. So we continue tomorrow.
कल आधे दिन की है सर, tomorrow half day is.
At 12, please try to conclude it within 1 hour. Well,
Sir, actually,
you have already prepared. You have you have been the council. You have been the council.
Sir, I was I actually want to avoid that. I wanted to
Because the certain part of the preliminary also has to be done. That you have done today. So you will be on marriage now. So marriage tomorrow. 1 hour. Be quick. You can be more quicker than others. We can expect that.
He has been dealing with emergencies only throughout his career. Whenever required, quickly.
Ah, 12.
Obliged. Your Lordship has also, my Lord, that Surajmal Meena appeal has been clubbed.
Yes.
which is in
We
supplement.
had also asked Mr.
So-
Rajan Prashad, we had also asked you about what would be the present position. What do you have from SOG as on today? Initially, we had asked you. You said we will place it.
No, that I will have to call, my lord, if you're.
That you call and you please
Yeah.
place it on for us.
Yes, yes.
We would like to know
My lord.
from you because that was the premature stage, let us say,
Yes,
25.
Today, my lord, what is the position?
What is
I-
the
Yes,
position?
yes, my
Please
lord, I
get
will,
it from your officers. We
Yes.
want to know
certainly,
ultimately.
certainly,
If you
my lord,
think
I
that
will.
yes, we have concluded, we have already identified everyone else. Or still you are you are just groping in the dark. We would like to know from you.
Yes, ma'am. There is, my lord, that Surajmal's case was a judgment in comma. The other appeals I am giving it so that they are also taken.
Surajmal was the one
Exception
which has been remanded back, which has to be heard by 31st March.
Yes.
All right. So we will have a continuous.
So these appeals are on. Same.
We will- I will tell my colleagues at Jodhpur that I am not going to sit there now because these orders have been passed here.
Same order appeals are there, my lord, they will also be reflected.
Yes, we will continue with regard to those cases in February.
That has been listed.
All right, we will hear it, but we will hear it. We'll pass a judgment by 31st March in those cases in continuity. But first we are hearing this.
No, no, I am saying.
हाँ take कर club कर. Yes. No. In all those cases, notices have been issued. इनकी कल लगाइए अलग से नो कल लगाइए इनको उसमें नोटिस इशू करने पड़ा ऑर्डर तो एक ही हुआ है तो फिर then you can say this that whatever you have to argue you will argue in that we will dispose it of all these appeals we will get them listed tomorrow and you make a statement we will then yes what do you have to say ये जो आज अर्जेंट मार्क केसेस है ना